Good morning again. Yesterday I started my presentation by telling you that as lawyers we're particularly upset about the use of the word attack, because attack, as used in the technical or operational sense, is not the same as the term attack as used in the legal sense. Now yesterday I told you that in the legal sense we have problems as well, because the word attack appears both in the jus ad bellum, the body of law, the body of international law that governs when a state can resort to force, and it also appears in the jus in bello, or international humanitarian law, the law of war, the law of armed conflict, with regard to the types of operations you can conduct. And so therefore, I want to distinguish today jus in bello attack from yesterday's jus ad bellum attack. It's very, very important. Several of the speakers yesterday mentioned the necessity of having an armed conflict before the jus in bello, before international humanitarian law applies. So I want to emphasize that this presentation and this use of the word attack only applies during an armed conflict. And just by way of review, there are two types. There is an international armed conflict that involves hostilities at any level between two states. The United States and Mexico start shooting at each other. We have an international armed conflict. This must be distinguished from what has captured the attention of the conference so far, and that's a non-international armed conflict. A non-international armed conflict is a conflict between a state and an organized armed group, like a terrorist group, or between an organized armed group and another organized armed group. But it's not so easy, because in international armed conflict, any level of hostilities suffices. But if you're talking about this non-international armed conflict, you must have a particular level of intensity of hostilities before the law kicks in, because it's not meant to govern civil disturbances and riots and so forth. So we need to be very careful. When we're applying this concept, you must apply it either in an international armed conflict, which is pretty easy to identify, or a non-international armed conflict, which isn't so easy to identify. Now, why do we care about the word attack in the jus in bello? We care because of the principle of distinction that is set forth in Article 48 of the additional protocol, the first additional protocol. By the way, some countries, like my country, Israel, Turkey, a few others, are not party to this instrument, but virtually all of us recognize this as an accurate restatement of customary law. This is the mother of all IHL principles. This is the jewel in the crown of IHL principles, and it's very, very simple. It says that if you're going to conduct operations, you must distinguish between civilians on the one hand, combatants on the other, between civilian objects on the one hand, and between military objectives on the other. The question is, though, that we'll play with today is what's the practical effect of Article 48? What does that mean in the cyber context? Well, fortunately, the additional protocol operationalizes this. In other words, it makes it practical in a number of provisions. The two most important are set forth at the top of the slide. The first is found in Article 51. And Article 51 tells us we may not attack civilians. So here we see the term emerging for the first time. And then Article 52 says we may not attack civilian objects. And then if you go through the protocol, or if you go through a U.S. military manual, we're not party to the protocol, as I mentioned, you'll see the word attack appear over and over and over and over. No such thing as indiscriminate attacks. The rule of proportionality applies to not military operations, but attacks. No attacks on objects indispensable to the civilian population. Precautions in attack, that bill we'll be talking about in just a moment. Precautions against the effects of attacks. So the legal question we have at this point is, what do they mean by the term attacks? Because it's particularly relevant in the cyber context. Well, The protocol on this point, it's not always so good on defining terms, but on this point, the protocol actually because this is so important, the protocol actually has a definition of attacks. It's found in Article 49. You should commit this to memory if you are an attorney. Acts of violence against the enemy, whether in offense or defense. The critical components here are violence and whether in offense or defense. Let me address the second one first, because I was asked a couple questions at breaks. It is important to emphasize that when we are talking about attacks, as a matter of law, as a legal term of art, we don't care if you're shooting at the person because you are conducting offensive operations, or you're shooting at the person because they're trying to kill you and you're defending yourself. An attack is simply transmitting violence from yourself to civilians, civilian objects, or military objectives, combatants, okay? So offense, defense, for the techies who often worry about defensive cyber stuff, don't worry about distinction as a matter of law. The first point up here is violence, and this is very important because we're wanting to know what does attacks really mean in practice. And the concept of violence is, again, repeated over and over and over, and it kind of means classic violence, what you think of in lay terms as a violent act. Dangers, violence, loss, injury, damage, losses. The commentary tells us that it's an operation during which violence is used. And then in another very famous but unofficial commentary, it tells us it means physical force. So we've moved from operations, and operations kind of means attacks generally. Attacks kind of means violence. What's our legal result in the cyber context? The legal result is that we can say with great certainty that an action that is nonviolent in character is not governed by the prohibitions on attack. So we're talking espionage and PSYOPs. In a PSYOP, you may direct your operation against the civilian population, but that's not prohibited by Article 51, the prohibition on attacking civilians. It's not prohibited unless it causes certain effects. Okay? So it's not merely directing, you have to have consequences. The problem is when we think about violence, the question that's always asked, yeah, but does that apply to cyber operations? Because cyber operations are not violent in and of themselves. I mean, if I shoot Soyun, that's a violent act. It's kinetic. It immediately causes effects. But if I beam electrons at her computer and this causes something that causes harm, physical harm to someone, that's kind of not the same. So over and over, particularly in the early days of cyber, the question was, does this rule apply to cyber operations? The answer today is absolutely yes. There's absolutely no question whatsoever. Anyone who argues this point doesn't know what they're talking about, because there's almost unanimity on this point. You should not worry about the fact that the means are not violent. You have to focus on the consequences of the operation. It's not the nature, it's the consequences. And this is consistent with our interpretation of this term in other contexts. For example, biological warfare isn't really kinetic, but no one in this room would suggest that that's not an attack. Or chemical warfare need not necessarily be kinetic, but no one in this room would ever suggest that that's not an attack if you conducted such an operation. So today, this question that everyone seemed to be struggling with 10 years ago has been asked and answered, and you need not concern yourself with it any further. The question, though, is what we know it's violence, we know its consequences. So operation, attack, violence, consequences, but which consequences qualify? And I believe that the answer here is found by looking at what international humanitarian law seeks to prevent. And the best place to look, at least in my estimation, is at the rule of proportionality, because the rule of proportionality is very clear. It says, listen, you can conduct military operations. You can even conduct military operations that harm civilians. So long as those military operations that harm civilians do not result in excessive loss of civilian life, injury to civilians, or damage to civilian objects, or a combination of that. So the type of violence, remember operations, attack, violence, consequences, the type of consequences you're looking for are death or injury to individuals, or damage or destruction to property. And this can occur either because you strike the target and it's a consequence to the target, or you strike the target and the target has no damage, but there's a residual effect on the civilian population that would qualify as collateral damage. In either case, we are talking about an attack. So if I attack her computer, she's in the military, congratulations, United States Marine Corps. You're in the Marine Corps, I attack your computer, it causes no damage here, but it harms this civilian over there in some way. That is an attack against a civilian, okay? Now, let's start, now we know what it is. So let's start applying this concept in particular circumstances. It seems to me that, and most international law scholars and practitioners, that it includes, this concept of attack includes damage that is not directly caused. So when you are looking at one of these situations and you're trying to find the damage that will qualify your operation as an attack, such that the law kicks in, the prohibition on attacking civilians, attacking civilian objects, you need to look further than what the immediate direct effect of my operation is. You have to ask, does that operation cause consequences, second, third, fourth order consequences, reverberating consequences? In the United States doctrine, we call them indirect effects. Does it cause those effects, and do any of those effects qualify? Death, damage, destruction, injury. Are any of those secondary or tertiary effects qualifying the operation as an attack? Because if they do, then it will be forbidden under Article 51 or Article 52 if they're civilians or civilian objects, okay? Now, the classic example is the one I use up here. Everyone likes to use it because it's easy to get your head around. I attack a dam. It causes no damage. All it does is cause the floodgates to open. Water rushes out. It rushes downstream. Clearly, those secondary effects on the civilian population downstream as a result of the flood qualify this as an attack. It also includes, and we talked a little bit about data yesterday, it also includes attacks on data if the attacks on the data cause those indirect effects. We said yesterday in the context of the jus ad bellum, but it applies to some extent in the jus in bello, that data is not property. Okay, it's not an object. That is not an object as a matter of law. However, if you attack data and it has those effects, then it will in fact be an attack. It would also include illness and serious mental suffering in terms of the cause. Data transferable to tangible objects was something I thought up in an article a long time ago, and the jury's out on whether this is true. And the example you use is, I take my ATM card, I go down, I stick it in a machine, and 100 euros pops out. My banking data is immediately directly transferable into a tangible object that can be damaged, okay? So if you attack my banking data, you're really depriving me of the ability to access tangible stuff. This, in this particular case, the jury is out. 50% say yes, 50% say no. Data like that, even data like that, even data that's directly transferable into something I can touch, that I can put into my pocket and hand to Katerina, even that data is not included. So damage to that would not qualify the operation as an attack. It includes delayed effects malware. This is something the techies brought up to a group of us who are working on the subject. They said, listen, I can put malware in and it goes off later down the line when the target does something. This, delayed effects, would be included in the effects that are acceptable. How do we know this? We know this because when we look at the negotiating history of the additional protocol, it tells us that using landmines is an attack. Even though the effect doesn't happen until well down the line, if I go dig a hole out here and put a landmine, I've conducted an attack, because the kinetic effect is going to occur. Attacks don't need to be successful, just like regular kinetic attacks. You can try, and maybe your malware never gets through the, into the enemy system. If that happens, that's still an attack. If I shoot a gun at you and I miss, I've still attacked you. It's exactly the same way in cyber. And so if you're a civilian object and it's going to cause those harms, that level of harm, that would still be an attack, even though I'm completely unsuccessful. What about the unwitting intermediary? Something that those of us who were involved in kinetic warfare never think about, but the cyber folks brought it up. What if I send an email to Katerina, and Katerina, it automatically then forwards it unwittingly. She doesn't know what's going on, to Soyun. This is an attack by me, but it's not an attack by the intermediary. Okay? It doesn't qualify as an attack. She has not violated Article 51 or 52. And then we come to the most interesting question. What if you attack using cyber something and you don't actually break it? There's no physical damage, or the persons aren't injured, but it doesn't work anymore. You have interfered with the functionality. I think we're starting to emerge to the point in the IHL community that if you do interfere with the functionality, it doesn't work, not the data, it doesn't work. Then if that's permanent, or if it must be repaired, that will qualify as the damage necessary to make that operation an attack. So if she's a civilian and I do something to her computer so that her computer doesn't work, or she has to take it to Bill's repair shop to get it fixed, I have attacked a civilian object, even though there's nothing really broken in a physical sense on her computer. And I think slowly but surely the international community is now accepting this premise. There are some alternative views in terms of what qualifies as an attack. The same scenario I've just used, I attack her computer, but instead of having to take it and get it repaired, some physical component replaced, for example, she has to reload the operating system. Many people say that is also an attack. That qualifies as the damage which is necessary for an operation to qualify as an attack. And I have to be frank, I'm slowly coming around to this view myself, because I'm struggling with the difference between replacing a component and loading an operating system. All I know is I don't know how to do either of those, so I've got to go to some computer goober and hand my computer to them. It's the same effect on me. So I'm slowly coming myself around to this view. There is another view, very much like the ad bellum armed attack view. There's another view that says you're too obsessed with the nature of the consequences. Look at the severity of the consequences. It's not whether I break that computer a little bit and she has to go to a repair store. The issue is how serious are those consequences? And so these people would say, we're looking at the wrong thing. If I conduct cyber attacks against an economic structure, economic infrastructure of another country, even if it doesn't cause damage, if the consequences are really severe for the population, that is an attack. That may be, in my mind, that may be lex ferenda, what the law will be. At this point, I don't believe it's the law today. And then finally, there's a group that has been saying for a long time that the issue is not the consequence, but instead the status of a target. In other words, if you shoot cyber at civilians, or you shoot cyber at civilian objects, then that's a violation of international humanitarian law, irrespective of the consequences, unless the consequences are truly de minimis. I believe that it's fair to say that this viewpoint, which was very strong early on, 10 years ago, this was a very strong viewpoint, is slowly fading away. Because these folks are struggling to answer questions like, well, but what's the difference with PSYOPs? I conduct the PSYOPs. If I want to go into an enemy's television broadcast station and put cartoons about their glorious leader, is that really an attack? Has IHL meant an attack? So I think this view is fading away, but there's still a few dinosaurs out there that hold it. There are key related issues. I will not talk about them. because my friends will talk about them. Military objectives, which Dr. Meltzer will talk about. I would emphasize that when he talks about that, the U.S. has a position. Niels, I don't know if you're going to talk about the U.S. position, but you probably want to ask him about it if he doesn't talk about it. Proportionality of attack. If you're doing an attack, it's not just about have I conducted an attack. There are limitations. Even if I can lawfully attack that military objective, I have to apply the rule of proportionality. And then my friend Air Commodore Boothby will be talking about precautions in attack. Okay, I have 8. How German am I? I'm down to perfect, okay? Let me tell you what Mike Schmitt thinks the future is going to be. I believe that the threshold for damage necessary to qualify an operation as an attack will drop somewhat, because I believe that this argument about severity has legs. I mean, it makes sense to me. My mission is to find what the law is today. But when people tell me, yeah, Mike, but cyber opens up a possibility to create really radical, dramatic, severe effects, I kind of understand. My gut tells me, the human gut says we ought to be worried about how serious something is, not the nature of something. So I think we will see this threshold drop over time through state practice, that the prohibition will be a little bit lower. There is a danger. It could go the other way. Because, listen, I teach at a war college, I know this. Capabilities always seek targets. When a capability is developed, warfighters, thinkers, operators always say, I can do this. I was one of the old guys who started dealing with cyber a long time ago, and the wireheads would come in and they'd go, hey, man, you know what we can do? Because they could do it, they want to do it. And there's actually still an element. I've heard that at this conference. Look, man, I can go in and I can turn on the camera, you know. Capabilities seek targets. This is a truism of warfare, but I'm hoping the first bullet is more accurate. I do believe that economies will be seen as a civilian object over time, and I'm absolutely pessimistic about the idea of new law in this area. This change will come not through the revolution of new law, but rather through the evolution of contemporary understandings of the current international humanitarian law. Thanks very much.
Thank you.